scope representation ends and what to do if you need further legal help. St. Louis, how are you doing today?
I'm doing great. How are you, Steve?
I'm doing well. So let's start with the first part of this question. When does limited scope representation terminate?
The answer is always all of our clients and potential clients' favorite answer. It depends. It depends on a couple of things. One, it can be based on agreement. Like we have been hired for a limited scope of a project, or a limited scope of like a restraining order hearing when we're just going to a discrete hearing, then our representation will end based on agreement. Sometimes it's just that it ends based off of the client no longer needs advice. So in other instances, we will be advising throughout an entire case. And whether we are then drafting the documents or reviewing the documents at the end to then finalize everything, it can end when the case is over. So there's a lot of with limited scope. There's a lot of control that the client has. There's a lot of control that we have in order to determine how much we're going to do and when, and then client can determine when they no longer need the advice or services. So it kind of just depends on the client's needs.
So it comes to an end. One way or the other, your services stop. What happens after that? Is there some sort of notice that goes to anybody? What happens after the end of it?
Again, it depends. If we're handling a hearing on a limited scope, then we will withdraw from the case. Most of the time, we aren't necessarily attorneys of record, so notices don't have to go anywhere. Essentially, clients and attorneys have the conversation, and they just say, okay, I no longer need help at this time. If that changes, then we can just kind of pick back up where we left off, or help with another piece of the case. But it really just it just depends on what the client's needs really are.
And that kind of leads into the last question, the second part of it, which is, let's say I need further assistance. It either we're in the middle of the case and you've done all this stuff, and I'm thinking, hey, I want you to do some more. You're doing a good job, and or a year later, what would I do as the client to get that extra assistance?
Yeah, I mean, the easiest obviously is anybody can call our office and can always talk to our team. They know what's going on in all of our cases from a case management software that we have. So they can look up who our client is, what type of agreement, who the attorney was, who the paralegal is, and then we can get, if it's been a good amount of time, then get back in touch with them and have a conversation about what's required next. Most of the time, it's kind of an ongoing relationship where then our clients will just email their attorney and say, hey, I need to schedule a meeting, or I need to schedule a phone call to go over the next phase of our negotiations. And then we'll jump on a call and go over that. So, it's dependent on whatever the kind of stage of the case it is and how long it's been. But we're flexible. We can do it anyway, essentially.
That sounds cool. It sounds like the client isn't at the very beginning forced to make a decision. I want just this, and then be stuck without that. There are a lot of ways that can be adjusted into whatever they need.
Yeah, and then a lot of times as well, we'll have somebody start where they feel like, okay, yeah, we're just going to negotiate. It'll be pretty straightforward and easy, but then things break down or things get more complicated, and then court happens. well, then we can be hired then to jump in and to handle the case on a full representation basis at that point, to then take over the case and see it through to the end. So there's a lot of different options. We already know the case because we're working in the background, or we're working to advise anyway. So then we're just, as long as we have enough time and we have that conversation about when the hearing is, when trial is, what are the issues, what's the evidence, discovery, all of these things, then we generally have the opportunity to then take over the case, to be able to represent client in court, to see it through to the end.
I like it. Last question. If someone else, they had been working with another attorney or by themselves, and they're halfway through the case is over, and they got to now figure out what to do, something happened after the judgment, can they still come to us for limited representation?
Yeah, yes. In our consultation, when having a conversation with myself or one of our other attorneys, we'll help our potential clients understand if it's something that we can help with. Can we jump into a case at that point? Are we up against too close to trial where, we generally, if we don't have about 45 days, like we can't jump into a trial because we need to be able to get the case worked up properly, for the court, and to make sure that we've got all the evidence and understand the case. So there are constraints on those type of things after a case is done. Something like in Oregon, we can't modify property division. So if somebody comes to us after the fact and the judge has ruled on property division, we can't go and modify that. There may be appellate, things that somebody can do, but that would be a different attorney that would handle that. So it really just, I would say, always call us, ask the question. We'll be able to answer if it's something that we can actually help with or not, or if we can't, refer to an appellate attorney, or, just understand that we need to modify later, and this is what modification looks like down the road, and have that conversation.
I like that. Well, thank you, Louis, for sitting down, joining us, talking about when limited scope representation ends and what to do if you need further legal assistance. So thanks today.
Yeah, you're welcome, Steve.
And thank you, everyone, for joining us. If anyone has further questions, as always, feel free to contact our firm and we can get you connected with an attorney who can help you. And until next time, stay safe, stay happy, and be well. Okay.
Okay, bye.
I'm Steve Altition, Director of Client Partnerships at Pacific Cascade Legal, and I'm here with our founding attorney, Louis Landerholm, to talk about how long modification cases take and how to make them move more quickly. Hey, Louis, how are you doing today?
I'm doing great. How are you, Steve?
I'm doing well. So let's start with what kinds of things can be modified in a divorce or family law case.
Sure. Yeah. So in Oregon, Washington, there can be different answers in Washington, but I'll talk about Oregon since that's what I know, and we handle both Oregon and Washington cases, so we can consult on a Washington case to determine what can be modified. But in general, property division cannot be modified in Oregon. What can be modified are anything to do with a parenting arrangement, parenting schedule. Custody can be modified. Custody can be very difficult to be modified, but it can be modified. Child support can be modified. Spousal support can be modified. Generally, anything with ongoing obligations can be modified. The property division is a point in time division, and so that it cannot be modified. So, but everything else potentially can be modified.
So what just to expect on the time frame of modifications? And I imagine that also differs with what it is you're trying to modify.
Sort of. It also depends on the county. Every county handles modifications a little bit differently. From a standpoint of a lot of counties will set status checks along the way, trying to help to force settlement and to force, the parties to agree. Other counties set dates. Modifications don't have the same level of like urgency for the court to necessarily get them done within a certain amount of time. Like a full divorce case, the court wants them done within a certain period, 9 months to a year, somewhere in there. Modifications, they in some instances will take 6 months. Other instances they can take 12 months. From the date of filing all the way through. So it really just kind of depends on the process that the courts follow. And the more complex custody cases will take longer. A lot of times for a modification, more so than even the original one, and we use them a lot. Like a custody evaluation will become important, and custody evaluations can take 6 months by themselves. So, custody modifications can take a long time. And depending on the facts, it could be a pretty straightforward modification. It's all over the board with modifications. So it's really a factual analysis on what needs to be modified, whether it's a spousal support, child support. Modifications can be pretty straightforward depending on what's actually being modified. The easiest thing to do is, we offer consultation. So in a consult, then we will go over what the original judgment says, and that brings up another point that what people and clients don't necessarily understand is whatever was in that original judgment is what a modification is being based off of and judged off of. And so sometimes, like in a spousal support modification, if there aren't good facts in the judgment, then we may not be able to modify it. If people handled the judgment on their own, or the facts were not done properly, our hands can be tied in a future modification if we don't have the original facts. The other thing is that for a parenting plan modification or a custody modification, anything that happened prior to that initial judgment is no longer relevant to the modification. So you can't bring up facts that existed at the time 5 years ago, if your judgment was entered 4 years ago, to then ask for a modification later because you needed to bring that up at that time. So consultations on modifications are really important because we have to go through and we have to analyze the initial case versus what are the new facts, and is a modification even appropriate. Washington modifications are more difficult because you have to prove certain elements to even ask for a modification. Oregon, we can pretty much ask for a modification whenever we want, but it doesn't mean that you're going to win. So we want to go through and actually analyze it and come up with a legal opinion as to what we think is going to happen when we get to court.
Well, that makes sense. I know a lot of times modifications, like you said, require some sort of a change from the original situation, and I would imagine that if you're trying to modify something 3 weeks later, it's pretty tough for that change to have occurred.
Yeah, not always, but I mean, for example, somebody moves from Oregon to Florida 3 weeks later. That could be a change. That could be something that does cause an immediate change. It's also that sometimes the original case can last a year and a half, 2 years, and you get to the end and something actually has changed. It's not normal and typical, but it doesn't necessarily mean that you're foreclosed from a modification. It may be with a 3-week period. It may be that it's an appealable issue, and so that's a different legal remedy. But that's why we have consultations to go through and have that conversation. And there are plenty of times when I talk to somebody where I say, now's not the right time. I would not bring a modification now. These are the things that you want to document and keep track of. And, we need 6 months, we need 8 months, a year, whatever it is, depending on the facts and depending on what we're trying to modify. Every case can be different. For example, like a spousal support modification, a lot of times modifications occur around retirement age. Well, if the problem is that we have to be able to prove to a judge what that retirement income is going to actually be. So until we know that information, it's not, the timing isn't right to actually bring that case. And so you kind of get stuck in a catch-22 as somebody who's paying spousal support, because if you need to modify, you have to wait until you know what your income is. But then when you wait, you're paying this higher spousal support with your lower income. So it can be, kind of a balancing act with trying to get a case moving with the retirement information. But that's what we go through to help everybody understand when we're when we're advising what course of action in a consultation.
Yeah. So after modification starts and the case is ongoing, what can make a difference between the modification being completed sooner rather than later? What can people do to help move the modification along, or at least not prevent it from moving along?
Yeah, I mean, most counties in today's world, require mediation. So getting into mediation sooner rather than later. Discovery, the actual act of gathering documents and gathering any evidence can impact the overall length of time, because we have to be ready with any evidence. And so really evidentiary wise, just being ready as soon as possible, and controlling what we can control. We can't control the opposing party. We can't control opposing counsel, and we can't control the courts. So what we can control is ourselves being prepared, getting the evidence ready to go as soon as possible, and then we're prepared and we're ready. I mean, sometimes we get court dates and it's set for a week out, and the court tells us we don't have a judge. That's outside of everybody's control, right?
Yep.
And now we're being bumped out 3 months. And that just happens. I mean, it's just the court resources are what they are, and is a part of the system, and that's why we try to help our clients negotiate and settle as much as possible, so we have as much control over the process. But there are things that just inevitably come up that causes the timing of cases to get out of control and to not happen when we want them to necessarily happen. But those are all of the so the best thing we can do is just be ready as soon as possible, and then when that time comes, then we get into court or we get into a mediation session to try to settle.
I love it. Well, thanks, Louis, for sitting down to talk with us today about just how long modification cases can take and how to make them move more quickly. Thanks again for joining us.
Thank you, Steve.
And thank you, everyone else, for joining us. Until next time, be safe, be happy, be well. And if anyone has any questions, feel free to contact our firm. We will get you connected with an attorney who can help you. Again,